Welcome to our California Real Estate Exam Prep video series. We'll give you 20 daily practice questions for the next 100 days with detailed answers to help you pass the exam and get your license. If you like our videos, please like and subscribe. Let's start now. 1. A mechanic's lien filed today would usually have priority over A. A trust deed loan recorded against the property before any work was done. B. A tax lien to be filed tomorrow. C. An unrecorded deed delivered a week ago. D. Both B and C. Answer: C. Recording gives priority. The first to record is generally first in right. 2. All of the following are correct statements about life estates except A. A contract creating a life estate must be in writing to be enforceable. B. A life tenant does not hold fee title. C. A life estate is a freehold estate. D. A life estate may not extend beyond the life of the life tenant. Answer: D. When the holder of a life estate, the life tenant, is a person other than the person on whom the life estate is based, the designated person, the death of the holder does not extinguish the life estate, but it passes to the heirs of that person until the designated person dies. Three. The Federal Truth in Lending Law defines the annual percentage rate which is charged on a real estate loan. It is the A. Total of all costs which the borrower must pay including taxes, closing costs, and title fees. B. The total of all direct costs of credit which the borrower must pay. C. Relative cost of credit expressed in percentage terms. D. Sum of all direct or indirect costs of credit which the borrower must pay. Answer: C. The annual percentage rate is the cost of the credit expressed in percentage terms. The total of all direct costs of credit which the borrower pays is the definition for the finance charge. Four. Mr. and Mrs. John Snyder sold their home to Robert Bingham using an agreement of sale contract. From a financing standpoint, the Snyders' relationship to most closely resembles that of A. Landlord to tenant. B. Beneficiary to trustor. C. Optioner to optionee. D. Grantor to grantee. Answer: B. A land contract is a security device by which a seller extends credit to a buyer. In the use of a trust deed, the beneficiary is the lender and the trustor is the borrower. 5. The Commissioner's regulations require that there be a written employed by that broker. Such employment agreements must be kept by A. The salesperson, for a period of 3 years from the date of signing the agreement. B. Both broker and salesperson, for 3 years from the date of the cancellation of the agreement. C. The broker, for a period of 3 years from the date of signing the agreement. D. Both A and C above. Answer: B. Both parties to the agreement must keep a copy of the agreement for a minimum period of 3 years following the termination of their agreement. Six. Mr. Brown hired a broker to find a warehouse for lease and agreed to pay a commission for the service. Several days later, Mr. Green tells the broker he has a warehouse for lease and agrees to pay a commission if he finds a tenant. The broker writes up the lease, which is signed by both parties. Brown knows that the broker was representing Green, but Green did not know that the broker was representing Brown. Which of the following is correct? A. Brown is liable for commission. B. Green is liable for commission. C. Both Green and Brown are liable. D. Neither is liable. Answer: D. Since the broker is representing both parties, they both must have knowledge of his dual agency and give their consent, or neither is liable for a commission. Seven. When can a broker or a salesperson represent both parties in a real estate transaction? A. When she discloses it to both parties. B. When both parties give written consent to it. C. When she acts with equal fiduciary relationship to both parties. D. All of the above. Answer: D. Agency disclosure must be made as soon as practicable. When acting as a dual agent, the agency must be confirmed in writing. The agent also owes fiduciary duty to both parties in the transaction. 8. What happens if a seller decides that he no longer wants to move and cancels an exclusive right to sell listing agreement with the broker? A. Nothing. B. The broker is entitled to full commission. C. The seller is liable for the broker's expenses. D. The seller cannot cancel an exclusive right to sell contract. Answer: B. According to the listing agreement, seller agrees to pay to broker commission even if, without broker's prior written consent, the property is withdrawn from sale, conveyed, leased, rented, otherwise transferred, or made unmarketable by a voluntary act of seller, during the listing period, or any extension. 9. A salesperson helps a buyer find a loan. She explains all of the conditions of the loan to the buyer. The total finance charge statement must be given. A. Within 3 days of receiving the loan application. B. Within 10 days of receiving the loan application. C. It does not need to be given if he explained all the terms. D. At the closing of the loan. Answer: A. Regulation Z requires that the total finance charge be given before the consummation of a loan. In the case of home loans, RESPA requires that it be disclosed within 3 business days of receiving the application. Contingency in a contract should: A. Carefully specify the details of the condition. B. Be vague to allow for the most interpretations. C. Not be present in a contract. D. Be in the contract only if the real estate agent approves the terms. Answer: A. 11. Where can you file a complaint under the Fair Employment and Housing Laws? A. Federal Court. B. Department of Fair Employment and Housing. C. Civil Court. D. Superior Court. Answer: B. Violations of the Fair Employment and Housing Act are handled by the Department of Fair Employment and Housing. If a violator cannot be persuaded to correct the violation, the department may file action in Superior Court or with the Fair Employment and Housing Commission. 12. What is the main advantage of a land sales contract versus other forms of financing? A. The owner keeps equitable title. B. The financing may be easier to obtain when other options are limited. C. The owner keeps actual title until the last payment. Answer: B. The primary purpose of a land sales contract is that it offers a way of financing when other options for the buyer are unappealing or impossible to obtain, and the seller wants to cooperate to make the deal happen. 13. In a contract, valuable consideration can be considered. A. Anything deemed of value. B. Service for service. C. $1 or more. D. All of the above. Answer: D. The concept of valuable consideration is not restricted to money. It can any of the above. 14. The seller's agent makes a false statement unknown to the seller. The buyer discovers this and backs out of the sale. The seller tries to enforce the sales contract. What is the most likely result? A. Buyer has recourse against the seller. B. Buyer will sue the agent and the principal for fraud. C. Seller will sue the agent for fraud. D. Agent will sue the buyer. Answer: B. Any contract made under the influence of fraudulent information is voidable, and the person making the fraudulent statements may be liable for civil or even criminal fraud. Where false representations are made by the agent, the defrauded third party will likely sue both the agent and principal. The innocent principal, in this instance the seller, may be relieved of liability in a court action for damages for fraud and deceit, but the defrauded third party may nevertheless rescind the contract. The guilty agent may, of course, still be liable for damages for the wrongful act. 15. A real estate salesperson has: A. The authority he thinks he has under the contract. B. The actual authority designated in the contract with the seller. C. The authority that other people think he has. D. All of the above. Answer: D. A real estate salesperson has implied authority, A. Express authority, B. And apparent authority, C. 16. Which of the following is not valid for transferring real property in California? A. Witnessed will. B. Nuncupative will. C. Holographic will. D. Statutory will. Answer: B. A nuncupative will is given orally, before witnesses, just before death, and the witnesses must then write everything down. Nuncupative wills are not valid in California or most other states. A witnessed will is a formal witnessed instrument, usually drafted by an attorney, signed by the testator and at least two witnesses. A holographic will is handwritten by the testator and must be signed and dated. Holographic wills are valid in California and most other states. A statutory will is a pre-printed or fill-in-the-blank form that is written according to the rules set out in the California Probate Code, or according to the laws of the state in which it is executed. 17. Acquisition of property during intestate succession is determined by: A. Probate court. B. A holographic will. C. A nuncupative will. Answer: A. A person who dies without a valid will has died intestate. The probate court determined whether a will is valid. If there is no will, or the will is considered invalid, the probate court will then determine the proper distribution of the estate, including real property. A project where there are common areas used by all, except for interests, for the use of individual living units, and managed by a non-profit association describes. A. Stock cooperative housing. B. Condominium project. C. Community apartment project. D. All of the above. Answer: D. The definition in the question describes a common interest development. All of the listed answers are types of common interest developments. In common interest developments, each owner owns a separate interest in the development, such as a condominium unit, for which they are individually responsible. Common areas, such as walkways, swimming pools, tennis courts, etc., are maintained by the association for the benefit of all of the owners. Some interests, such as patios, parking areas, utility lines, etc., lie outside of the boundaries of the individual unit and are technically part of the common area, but are reserved for use by a specific individual unit. The individual owner is responsible for maintaining those interests. 19. Broker Barbara worked for her father, Broker Bob. Broker Bob held several exclusive right to sell contracts with sellers. Upon Broker Bob's death, Broker Barb took over the firm. What happens to Broker Bob's contracts? A. Broker Barbara assumes contracts because of laws of inheritance. B. Broker Barbara must renegotiate the contracts. C. Broker Barbara assumes the contract because she took over the firm. D. Broker Barbara must file a court probate action to be awarded the contracts. Answer: B. If a broker in a large real estate office dies, all listings are automatically cancelled and the new broker would need to relist the properties. 20. The Principle of Conformity states: A. Houses in a neighborhood should sell for the same amount. B. The maximum value is obtained when a reasonable degree of building similarity is achieved in the neighborhood. C. The value of a particular component is measured in terms of its contribution to the value of the whole property. D. That when homes become older and the residents are long-time homeowners, the neighborhood achieves a solid, well-established look. Answer: B. B. Defines the principle of conformity. C. Is the definition of the principle of contribution. Thank you for watching. I hope you found this video helpful. If you did, please consider subscribing to our channel so you don't miss out on our future videos. We look forward to seeing you in the next one.